পরে উঠছি না
17th March.
Item number 6.
Let's 6 case 35 is
Ah.
the arbitration clause. The other side has taken time thrice, my lord, as every order is the last and so on.
Your Lordship, I'm apologetic.
But anybody, no, we have already.
Last chance, Your Lordship.
No, but you had undertaken
three
to
orders.
file January, sir.
Yes, my lord, 30th, my lord, on three occasions, my lord, your lordship may
Okay.
appoint anybody if they
Correct,
don't come forward with a name. Your lordship may appoint. We have already given our name.
Despite 3 adjournments, no reply has been filed by the Union of India. Opposite parties, on the previous occasion, an assurance had been given to the court that it would be filed by 30th January 2023, and yet it has not been filed. Paragraph. The court accordingly declines to grant any further time for that purpose. If you want to say something, you can say. No.
Only last chance, Your Lordship.
No. You say, having heard Mr. Pitamar Acharya and senior counsel appearing for the petitioners and Mr. So-and-so appearing for the opposite party, and leaving open all their contentions, all the respective contentions in law to be urged in the arbitration proceedings. What is the claim, sir?
Let the claim is around 200 crores, my lord.
200 crores.
Crores, my lord.
What is the clause envisages sole arbitrator or
No,
tribunal?
that is 3, my lord. We have appointed Dr. Adis Agrawal, senior advocate. Lord,
Oh, you
your
have already
lordship may
appointed.
nominate
So we'll
any-
give them time to appoint their own then. And if they fail to appoint, then
Your lordship may direct so.
you say,
Otherwise, my lord, any retired judge from Delhi Supreme Court or Delhi High Court, your lordship may nominate. It's a
no, but both of you to agree that it has to be a sole arbitrator.
no, my lord, we have my lord, let them appoint, let them nominate there. Let them.
You say, Mr. Acharya, no, Mr. Acharya informs the court that the petitioners have nominated
Yes, Dr. Adis Agrawal.
Dr.
C.
Adis Agrawal, senior advocate, as their arbitrator.
Yeah.
Paragraph. The opposite parties will now nominate their arbitrator positively on or before 31st March 2023 and inform the petitioners of such appointment. Stop. The 2 nominee arbitrators will then meet and appoint the 3rd arbitrator not later than 30th April 2023. Paragraph. If there is any failure to comply with the above directions, it will be open to the parties to apply to this court for further directions. The petition is disposed of.
That's obliged.
Item number 7.
Number 7, man. This is the second time it has been listed. The first time your lordship had issued notice, madam. We had filed a requisite. I don't know if anybody is appearing.
Service is complete or? What is this? No, what have you been given?
Sir. Yes.
आप मुंबई से आए हैं?
मुंबई से सर।
हाँ, आपको कोई वकील नहीं है?
नहीं सर, अभी मैं वकील तो अभी आगे आया तो मैंने वकील में आपकी आज्ञा है तो रख सकता हूँ, रखा नहीं।
हाँ, नहीं, बस ये आर्बिट्रेशन के लिए मांग रहे हैं। हाँ, आप राजी हैं?
सर ऐसा है, मेरे को कुछ आइडिया नहीं है। ये माल मेरे पास में 1.5 साल
Same
से।
matter, man.
Yes.
मेरे को बोलने की इजाजत चाहिए आपकी। बोलूं?
हाँ, बिल्कुल।
मैं माल देने के लिए एग्री हूं, परंतु मेरा आउटस्टैंडिंग पेमेंट है वो देके जाइए और इसका माल लेके जाइए। मैं ना नहीं बोल रहा, माल नहीं देता हूं, ऐसी बात नहीं है। माल मेरे पास में 1.5 साल से रेडी पड़ा है, 12 मीटर लंबा है, रखने की जगह नहीं है, दूसरों के गोदाम में रखा है, उसका भाड़ा लग रहा है। रही बात मैं देने के लिए एग्री, परंतु ये लोग मेरा पैसा नहीं दे रहे हैं। मेरा पेमेंट देके जाइए और ये माल लेके जाइए। जी सर।
आप मीडिएशन के लिए जाने के लिए तैयार हैं?
यानी मैं समझा नहीं।
मीडिएशन ऐसा होगा, समझौता के लिए एक सेंटर बनाया है यहाँ पर। आप भी पेश होंगे, इनके रिप्रेजेंटेटिव भी आएंगे वहां पर। आपस में बातचीत से आप सेटल कर सकते हैं।
सर बातचीत में मेरा जो आउटस्टैंडिंग पेमेंट है
नहीं नहीं, जो भी आप
वो
कहना
मैं
चाहते हैं,
दूसरा मेरे को कुछ
एक
करना
सीनियर
नहीं।
मीडिएटर होंगे वहां पर,
हाँ
आप जो भी रखना चाहते हैं बात अपना आप रख सकते हैं, ये अपना बात रखेंगे और एक सेटलमेंट के लिए वो ट्राई करेंगे बस।
और सर क्या मैं देने के लिए एग्री हूँ, मेरा पेमेंट देके जाइए और माल लेके जाइए, ये मेरे को ऐसे हरासमेंट कर रहे हैं। बड़ी पार्टी ये मेरे को हरासमेंट करे, मैं छोटा आदमी हूँ, मैं बम्बई से दौड़ दौड़ के आया हूँ, मैं 1.5 साल से ये लोगों को मेल कर रहा हूँ, फोन कर रहा हूँ, कोई रेस्पॉन्स नहीं मिल रही है। और जिंदल का आदमी आया, देखा माल रेडी पड़ा है, ये लोग मेरा पेमेंट नहीं दे रहे सर।
Why did you try mediation,
जी,
Mr.
I have
Mohan?
no objection, my lord.
Acha,
Whatever falls
all
in
right.
my lordship.
The respondent, the opposite party opposition
Just-
person says that he is prepared to settle his disputes with the petitioner. We'll stop. Mr. Mohanty, appearing for the petitioner, says that they have no objection to exploring the possibility of settlement through mediation. आपको दोबारा आना पड़ेगा।
ठीक है, आपकी आज्ञा होगी तो आऊंगा सर।
हाँ, अगला महीना आ जाना है या कब आ सकते हैं आप?
सर जो भी आपकी आज्ञा।
नहीं,
आपको कौन?
आप बताओ ना, आप मुंबई से आ रहे हैं?
अगले महीने की दे दो,
अच्छा,
मार्च की।
हाँ, अगले महीने 2 तारीख आ सकते हैं आप?
आप आ जाऊंगा सर।
कैलेंडर
1 मिनट सर, 2 तारीख ये तो कोई सा मेरे को
गुरुवार है।
गुरुवार। हाँ ठीक है, आ जाऊंगा सर।
हाँ, the parties will appear before the mediation center of the High Court. I think you may have to tell him where the mediation center
I'll
is.
do that now.
हाँ,
Right.
at 3 p.m. on 2nd March 2023, the coordinator of the mediation center is requested to assign a senior mediator to explore the possibility of settlement through mediation.
May
The mediation report be placed before the court before the next date. List on 21st April 21 अप्रैल के लिए लगा है कोर्ट में।
हाँ
यदि समझौता नहीं हो पाता है तो यहाँ हियरिंग होगा।
अच्छा, तो मेरे को 2 तारीख को आना है।
हाँ, 2 तारीख मार्च को आना है।
मार्च की 2 तारीख को।
हाँ
ठीक सर।
हाँ,
my lord, my only request is, my lord had fixed it at 3 p.m. Can it be at 4 p.m.? my lord?
4 p.m. Sure.
Great.
और at 4 p.m. और ठीक है।
बैठो, मैं आता हूँ।
Special list, trace admission item number 1, CRLMC 1876 of 2016.
None appears dismissed from prosecution.
Special list item number 2,
Come.
That matter, last time you noticed, they have given 2 judgments
Yes,
of Allahabad High Court.
correct.
Those 2 matters, my lord, those offences were financial. One of the offence was the, my lord, financial offence in the in PC Act case. Another was a case where, my lord, somebody has impersonated and sold the land, as that money he has deposited in the account. So that money has some link with this crime. But here in the case, there is nothing. It is a murder case and no link is there. And more particularly, the subsection 3 of section 102 has not been complied with. And the apex court decisions, that decision still stand to hold the fields, my lord. And you also have specific pose a specific question. What is the need of that attachment?
No, that was a point of law. Last time my argument was
102 CRPC.
Non-reporting to the learning magistrate regarding the freezing of our account.
No, he
that
was
appreciate that-
just CRPC. He's referring to 102. You have not followed.
Yes, that is non-reporting to the magistrate. That the exact language also has been used in the petition. And that's the reason why I have given the 2 judgments of the division bench of Allahabad High Court.
Where is that? In fact, your judgments.
I have given the state of UP versus what is it? 4112. It was given restriction number 11201 by 2021. No, I've given that. two judgments have given.
Ah.
There is state of UP and 3 years versus Manish Singh.
Hmm.
There also can come to paragraph 18. And the point that is held by the High Court. Plus, fourth line from the top, paragraph 18. Therefore, non-reporting of procedure forthwith, as provided under section 102(3) CRPC, Samla ipso facto, render the decision illegal, particularly as no period is specified and its consequences have not been proved. And there was Honorable High Court has dealt with this particular provision is not mandatory but directly.
No. I think the code is simply saying that you can now go to the magistrate and get it released.
Yes, Lord, because
So why should, I'm saying after so many years,
so for that aspect is concerned, whatever the judgment by render decided, that is correct, Lord. Correct position of law. That is a property under section 102 of CRPC.
right?
That part is clear. So then, no issue.
All right.
The land magistrate shall fix appropriate conditions and release that one.
Okay.
Am I not audible, plus? Probably I was not audible properly.
No, you are. Counsel for the state, you say on the previous date, the following order had been passed, then reproduce the order. Counsel for Mr. Katke, learned AGA, refers to the decision of the Allahabad High Court, dated 18th April 2022, in criminal miscellaneous writ petition number 11201 of 2021, bracket Amit Singh versus State of UP, and refers to para 18 of the said judgment, where it is observed as under reproduce 8 paragraph.
Your Lordship, also kindly read paragraph 13. Paragraph 13 for a moment, plus. I beg pardon, plus. That is subsection 3 of section 102 CRPC provides that every police officer acting under subsection 1 CRPC.
All right.
Shall put-
Both 13 and 18.
So the main
All right.
thrust,
13 and 18. You see, the above observations have been made after noticing the judgment of the Supreme Court in state of Maharashtra. This is Tapas Niyogi, 1999, 7 SEC 685. Paragraph. The sum total of the above passages is that it would be open to the petitioner whose bank account has been attached to move the concerned magistrate for releasing or defreezing of the account from attachment. Paragraph. Mr. Katke states that the state would have no objection to that course being adopted as far as the present case is concerned. Stop. In that view of the matter, it is directed that the petitioner will file an appropriate application in the court of the JMFC Kujang.
Now it is pending before the additional session judge Kujang.
Okay, before in the court of the additional sessions judge Kujang, where GR case number 963 of 2016 corresponding to Paradeep PS case number 180 of 2016 is pending, and seek the lifting of the attachment of the petitioner's bank accounts. There's a trial number. Full stop. After hearing the parties, the learned court will pass appropriate orders and impose whatever conditions it deems fit for acceding to the prayer of the petitioner regarding defreezing of the petitioner's accounts. Full stop. The court clarifies that it has not expressed any view in the matter.
Beg pardon, plus. My objection may be recorded, plus. Yes, I have objected. Your Lordship has said that I don't have any objection. I have objected to that. My objection may kindly be recorded, plus.
I thought you did well. You are now saying you objected. You never said you objecting.
My humble submission was probably I have not made a Lordship. I could not get your Lordship to the point exactly. Section 102 CRPC plus one contention that I am taking your Lordship to the brief. Then what my learned friend has stated. It's not that I am going back from my submission. No. He has his even his statement pleading is that the very reporting, the very freezing has not been reported to the magistrate. That
All right, just add a paragraph. You say Mr. Katke is unable to point out to the court in what manner the requirement and section 102 bracket 3 CRPC has been complied with in the present case. Full stop. Although the observations of the High Court in the above decision are to the effect that the non-reporting of the attachment to the magistrate may not be mandatory, as no consequences have been spelled out. The fact remains that the attachment is plainly contrary to the requirement of section 102(3) CRPC. Full stop. Therefore, the petitioner is fully justified in contending that the attachment, which is contrary to section 102(3) CRPC, should not be allowed to continue. Full stop. Then the same order. All right.
Only, my lord, that number has changed in the meantime. I am giving that number.
All right.
That GR case number renumbered as session.
All right.
I am giving that number.
GR case number, then say renumbered as after that. Yeah. All right.
Specialist item number 3.
None appears dismissed.
Specialist item number 4.
My lord, there is no instruction. Ma'am.
No instructions dismissed.
Specialist item 5.
None appears dismissed.
Item number 6.
None appears dismissed.
Item number 7.
No instruction.
No instructions dismissed.
Excuse my lord, item number 7. 7, my lord. Neither my name is in the affair nor in the charge sheet. Oh, sorry. Oh, sorry. Oh, sorry. I'm sorry.
Yes. None appears dismissed.
Item number 9.
And pardon, my lord, I am on VC, my lord. My
Yes.
lord, for quashing of the criminal proceeding and order of cognizance dated 17/10/2016, my lord. My lord,
This is
allegation
item
is
8, is it?
that-
8.
Yes.
My lord, allegation is that when the police came to the lodge to verify an immoral trafficking, one Sulochana Murmu disclosed that one Suraj sent her with the prisoner, my lord. My lord, section 3, 4, 5, 6, 7, 8 of the immoral My lord, the girl victim has not been made an accused, my lord, and the medical opinion in respect of the prisoner as well as the evidence collected do not make any case, my lord. My lord, moreover, 164 and 161 statement along
This
with
is
the-
302, sir.
My lord.
This is 302. The offense is under 302 here, sir, please.
My lord, section 3, 4, 5, 6, 7, 8 of the immoral
There was-
traffic act, my lord.
No, which is the matter you're appearing, sir?
My lord, item number 9.
9.
Item 9.
All right. 8, none appears dismissed. All right.
Item 9.
9, my lord, the girl victim has not been made an accused and the medical opinion in respect of the prisoner as well as the evidence collected do not any case, my lord. My lord, moreover, section 161 and 164 along with the FIR differ from each other, my lord.
So all right, sir, all these pleas you can take at the appropriate stage, permitting the petitioner to urge all the pleas at the appropriate stage in the trial.
My lord may allow for expeditious hearing, my lord.
That you can pray for, sir. The petition is disposed of, interim order is vacated. All right,
Item number 10.
Same, my lord.
same order.
Item number 11.
May I please, your lordship? Your lordship, all the offences are available in the nature tribunal magistrate first class. Your lordship may kindly issue notice to the opposite party number 2 because compromise matter has already been
Where is the compromise petition?
in the court below.
Then you pursue it there, sir.
Your lordship may kindly issue notice to the opposite party number 2 victim girl, my lord.
Not necessary, not at this stage, sir. You say permitting the petitioner to urge all the pleas available to the petition in the appropriate stage in the trial court. The petition is disposed of. Yes.
Specialist item number 12.
Item 12, lordship, I may be pray, my lordship, next week, maybe come next week, only whether the case is pending or not, only instruction maybe,
It's all.
only
If
petition.
it's not pending, it won't be pending.
Lord-
That's it. Or
Lordship.
permitting the petitioner to urge all the pleas at the
Lord-
appropriate stage in the trial court. Petition is disposed.
Next week, same Friday, lordship,
Not
only
necessary, madam. Not necessary. Yes.
2016, lordship, there is
It's
no
all right. If it's not there, then it's even better for you. Nothing has to happen. Yes.
rejecting
Item
the
number-
petition, rejecting the defer of the cross examination.
There is no interim order in this court. Matters must have progressed. So you can find out from your client at your leisure. Yes.
Item 13.
My lord, item 13 infructuous.
Dismissed as infractions.
Item number 14,
None appears dismissed.
item number 15,
But this is a peculiar case, my lord. In this case, neither in the affair, nor in the charge sheet, nor during the trial, my name is there, my lord. Only because IIC has submitted that others are absconding. For that reason, it has been kept, my lord. My name is there in the following report of the IIC,
Yes.
where he has mentioned that present petitioner Sagar Mahapatra and others are yet to be arrested and may other aspects. But in the affair, there is 5 persons. They all have faced the trial, and the main accused has been arrested and convicted, and others have been released, my lord. My name is nowhere in the. I have obtained the certified copy of the entire depositions and all. Nowhere my name is there, my lord.
So all the easier than for you to get discharged.
My lord,
Let's say counsel the petitioner seeks is permitted, sorry, this say permitting the petitioner to urge all the pleas at the appropriate station time. The petition is disposed of. All right.
until then, no arrest, my lord.
item 16,
I have challenged on the ground that since it is a special act under the electricity, my lord, the learned SDGM has no authority to take cognizance so far as the alleged offence is concerned. Your lordship may
What do
kindly-
you say, sir? Special act,
Yes. My lord, your lordship,
electricity act, how can is that the only offense?
379 and one,
7 is there.
Ah,
that is.
then only 135, 1A, you can talk about, you can urge that plea, not for 379. Even this plea you can take there, sir.
Since cognizance has been taken, my lord, your lordship may direct me so that I can raise.
There's
this-
no stay. What has happened?
No, it is, as it is pending, my lord, last.
How? 6 years now.
Because this application, copy of this, mentioned that we want to matter.
So automatic stay.
No.
This is what you people do. Just give the diary number to that
No, no,
court
no.
and say now it's in the High Court, don't do anything.
But now it is because the electricity department also has said that it has been filed. That is why they.
Orissa has very unique practices, sir. And all our subordinate courts also very happy. The minute they are told something is in the High Court, they keep quiet. They don't ask for a stay
Because
order.
the department has said that the appeal is pending before the application is pending before this honorable court. They had been proceed. That is the only difficulty, madam.
Automatic stay. Such cooperative people you have. Permitting the petitioner to urge all the pleas at the appropriate stage. The petition is supposed of. Your purpose is served. 6 years, everything is frozen.
No, my lord. This was earlier.
All
on.
right.
Result of long negligence, madam. Long negligence, it can't be revived so immediately.
Anyway, let's see. We have to do what we have to do.
Yes, there is no doubt in it, but
Right.
it is the result of long.
Correct.
item number 17,
Because of the long irregularity, we are accustomed in one manner, but we can't say to your lordship that not to act as per the law.
None appears dismissed. All right.
item number 18,
On behalf of Mr. Pal, permitted to withdraw.
Dismissed as withdrawn. All right.
item number 19,
My lord, there are two matters, my lord.
Hmm.
One is, my lord, arising out of complaint case
Hmm.
in which I am the complainant.
Hmm.
Died in the meantime, I have filed an application for substitution on 3/8/2022.
What is this complaint about?
Complaint, my lord, that is a, my lord, village dispute.
Why substitution and all then?
The
Once
village-
a person has died, why should you continue?
No, my lord. In that case, I am for the complainant.
I know, once the complainant has died, what is that? What is that great matter that his family should continue it? What is it? What is it?
Because, my lord, the trial after the death of the complainant, my lord, the
No,
trial.
what is the dispute? You're not telling me what the dispute is about.
Dispute is, my lord, totally is a village dispute.
No,
There is
village means
allegation-
what? Property dispute?
There is allegation that
This is ordinary hurt, 323, 324. There must have been a marpeat.
well, in their complaint petition, they have 12 to 40 to 50 co-villagers holding deadly weapon reached in front of the house of the complainant, and my lord, have assaulted them. That is the case, my lord. That is the case. And in my case also, my lord, that is
Cross case. Yes, it's a cross case.
cross case, my lord.
Ah.
My case is police report. Their case is, my lord, 160 case. my lord.
Correct. You see, permitting the parties to urge the respective pleas at the appropriate stage in the trial court. The petition set as post of the interim orders.
Both the cases. my lord.
Both.
Item number 20.
Well, item 20, I am challenged the order as annexure 3. What happened in this is the present petitioner lodged one affair that his son was died in a vehicular accident manner. Most surprisingly, the police submitted final report is a false case. Thereafter, I filed a protest petition. In the protest petition was dismissed on the two ground that I have not mentioned the father name of one of the witness and I have not mentioned the accused. But this is a vehicular accident. How I know the accused person manner? These two grounds my protest petition rejected, and the fact is that my son and another person, two persons are died manner in the road
So
accident.
what is it? The case was 304A.
No, 3 or accidental. 3 is 2, that is annexure 1, 279, 338, 304A.
304A.
Yes, but surprisingly, the police submitted final was a false case. Thereafter, I filed a protest petition before the magistrate.
Let's see the order.
Annexure 3.
This order is not convincing at all, Mr. Katke. Have you seen his order?
Yes.
If he's giving a vehicle number, the least you can do is ask the transport authority and find out. That should have been done.
Yes.
You see, the petitioner's son and one other person died in a vehicular accident.
Another person received grievous injury.
And GR case number 827 of 2016 had been registered on 24 June 2016 in the Kanjipani police station, district Kyoja, as case number 23 under section 279/338/304 capital A IPC. Paragraph. Upon investigation, a closure report was filed by the police, stating that an unknown vehicle had caused the accident. Paragraph. The protest petition of the petitioner referred to one Bansidhar Nayak, a resident of the village Jamuna Posi, as having noticed a vehicle, a Bolero vehicle, having caused the accident. So the number of the vehicle was also disclosed. Stop. The grievance was that the investigating officer did not examine Bansidhar Nayak and without proper investigation submitted the final form. Paragraph. The learned SDJM Kyoja has rejected the protest petition by the impugn order dated 30th May 2017 only on the ground that open quotation, the complainant does not mention the name, age, and other description of the accused in column 2 on the complaint petition. Unquote. Full stop. It is inconceivable that the complainant, who's the father of the deceased victim in the accident, would be able to know precisely the name, age, and description of the accused when, even according to the police, it was an accident case and they were in the dark about the identity of the vehicle. Full stop. With the complainant, with the petitioner complainant having offered the name of the person who had information of the vehicle and also given the vehicle number, it should not have been difficult for the SDJM to require the police to get the relevant information concerning the said vehicle from the transport department before simply rejecting the closure, the protest petition. Full stop. Paragraph. Consequently, the court sets aside the impugned order dated 30th May 2017 of the SDJM Kionjar and restores 1 CC number 49 of 2017 to the said court for again being proceeded with on the protest petition of the present petitioner in accordance with law. Stop. In particular, the SDJM will require the police to elicit the details pertaining to the vehicle number provided by the petitioner, from the transport department, and also require the police to record the statement of the said Bansidhar Nayak, who provided the information. Paragraph. The matter will now be listed before the SDJM Kionjar for directions. On 6th March 2023, a copy of this order be sent forthwith to the concerned court.
Item number 21.
Lordship, item 21 to raise all, VC Lordships. To
Yes.
raise all please at appropriate stage. Your
All right. Permitting the petitioner to raise all, please. With the appropriate stage. All right.
Oh, bless you, Lordship.
22.
22, may I please, Lordship, my lord, challenging the order of cognizance, my lord. The cognizance taken under section 498, 323, 307 and 506, my lord. The petition are all in-laws, my lord. The sole ground, my lord, there is nothing, marriage has a solemnity between the son of the petitioner and the infirm, my lord. By virtue of the certificate issued by the notary public, the present FIR has been filed and the London trial court has taken.
What happened in the divorce case? There must be a divorce case.
My lord, the marriage is under challenge. The date is posted to 10th February.
So there's no settlement, nothing.
Nothing, sir.
Then permitting the petitioner to raise all the pleas at the appropriate stage.
But there is no role of
There's
the
no
present
way,
petitioner,
sir,
lord,
unless
because
you
they are
people
all are
settle-
in-laws, lord.
You settle your disputes, everything will come to an end. That's the only way.
A marriage is solemnized between the son of the petitioner, son of the petitioner, present petitioner, and the informant before the notary public. My lord, your lordship very well knows that the value of the notary public. My lord,
I don't
evidential
know. I
value.
don't know. The trial court will know. All right.
Obviously.
Item 23.
None appears dismissed.
Item number 24.
24, no instruction. No instructions dismissed.
Item number 25.
None appears dismissed.
Item number 26.
My lord, 26, my lord. All the offences are tribunal magistrate, and annexed 3, the matter has already been compromised between the parties before the court below. In spite of a compromise, still then she has
This
filed
is
an
not
application.
compromise. It will have to be a
I may be
sworn
permitted
affidavit.
to move before the court below.
All right. Counsel, the petitioner seeks to leave to move the court below for appropriate directions.
Okay.
Granting him the leave, the petitioner is disposed of. The interim order is vacated. All right.
Item number 27.
None appears dismissed.
Item number 28.
28, my lord, may I permitted to raise the issue before the.
All right. Permitting the petitioner to raise all please. At the appropriate stage.
Item number 29.
None appears dismissed.
Item number 30.
Here the charge has already been framed, so it has become infructuous. I may be permitted to withdraw.
All right. Counsel for the Mr. Panda states that the charge has already been framed. He accordingly seeks leave to withdraw the present petition, disposed of his withdrawal.
Item number 31.
None appears dismissed.
32.
Lordship, I am permitted to raise all the points at the time.
Permitting the petitioner to raise all please.
Item number 33.
33, my lord, the petitioner has already been acquitted in the court below, my
All
lord.
right.
Matter has become infructuous.
Infructuous disposed.
Item number 34.
None appears dismissed.
Item number 35. My lord, permit to all the rest all
All right. Permitting the petitioner to raise all please.
Item number 36.
36, my lord. Petitioner become acquittal, my lord. So infructuous.
Infructuous. All right.
Item number 37.
Lords, the petitioner before your lordship is a doctor, my lords. A dead child was brought to him when he was in the hospital, my lords.
304A.
Yes.
Ah.
And he said that nothing could be done because the child was dead. Thereafter, my lords, an FIR was lodged alleging that the petitioner was inebriated and did not attend to the child, for which the child died. Your lordship may look at page 24 of the brief. That is the postmortem report. Postmortem was conducted on that day,
which shows, my lords, that the death has occurred in the late hours of the night and the child was brought dead. Cause of death is cardiorespiratory failure. And the doctor has said exact cause cannot be opined till reports from forensic research lab is obtained. Till date, my lords, the forensic report has not come.
What's your instruction, Mr. Katkia?
Annexure 5, your lordship may see my medical report. The doctor indicates on the same day I was arrested and I was examined. No smell of alcohol, speech is normal, gait is normal. So opinion is that he hasn't taken alcohol. He is a
No,
diabetic
but how
patient.
soon after we don't know this?
No, same day, my lords, in the morning
No, no,
the incident happened.
days. Anyway, let him on the
Yes.
forensic report, let him tell us.
No, I don't have any instruction, so I have taken instructions.
Mr. Katkia states that he needs time for instructions, particularly on whether the forensic report is now available with the police. List before the roster bench. On 20th March, interim order to cut it.
Obliged.
Item number 38.
An urgent copy of today's order.
Urgent copy.
Number 38, my lord. Arising out of a complaint petition, challenging the order of cognizance minor. Cognizance has been taken under section 420 and 506. Okay, complainant alleged that he paid money to purchase the land in an agreement.
If you don't compromise, this is what is going to happen, sir.
My lord, entire money, it is admitted by the complainant, the entire money has been returned by the.
Then all that we'll urge at the appropriate stage, permitting the petitioner to urge all the pleas at the appropriate stage.
Entire money has been
That's
returned, my
what,
lord.
so it will go for trial, so then no other option. Yes.
Item 39.
39 pass over, man.
All right.
Item number 40.
None appears dismissed.
Item number 41.
None appears dismissed.
Item 42.
No instruction. No instructions dismissed.
Item number 43.
May I please? I am challenging the order passed by the sub-collector Redakor. As the fact of the case is the petitioner filed a criminal miscase under section 144, 145 and 146. The learned sub-collector rejected that. We have filed the petition for restraint from the opposite party number 2 and 3 from the scheduled land.
So now you renew, sir, all this is dead.
My lord.
7 years old. Due to passage of time, the issues are no longer alive. Counsel, the petitioner seeks leave to withdraw the present petition with liberty to seek appropriate remedies if any fresh cause of action arises.
Obliged.
All right. Disposed of is withdrawn with liberty. Is paid. All right. All right.
Item number 44.
None appears dismissed.
Item number 45.
45 on behalf of Mr. Dayanda Mahapatra permitted to withdraw, madam.
Dismissed as withdraw. All right.
Obliged.
Item 46.
None appears dismissed.
Item number 47.
My lords, the cognizance is taken out of 307, my lords. There is no ingredient, nothing. My lords, allegations, there is a boundary dispute between the parties.
Mr. used a knife. What did you use?
My lords.
You used which weapon, sir? Knife or?
Nothing, my lords. No use. Nothing. No. My lord's allegation is that
there's no injury.
Strangulized the neck.
So you used your hands. You used your hands.
Neck. And 307, my lord.
Actually, there must be strangulation marks.
Even everything is accepted. No one will be 307.
Why? If there is strangulation marks, why will it not?
My lord, he was not examined. Wife says that my husband was attacked.
No medical examination.
Nothing, my lord.
There's no medical report at all.
Well, actually, I don't have the file in this case.
Mr. Katkia states that he needs time to ascertain.
I'll get the.
What is this, sir? This case also you don't medical report. Then what is this?
No, of course, no, sir.
Straight away you can tell if the medical report is there, not there. Why keep this man also hanging now? How many years now?
Well, it's 6 years, my
6
lord.
years, just like that. Everything can't be 307, sir. All right. You say Mr. Katkia needs time to ascertain what the medical report. There's no stay here.
My lord, nothing has happened there also. My lord.
Our courts are so cooperative.
I have taken instructions. Nothing has happened.
All right. You say list before the roster bench on 27th March.
Yes, I'll take a soft copy of the.
Please. That you don't even have to ask permission.
Person. Always.
Item 48.
None appears dismissed.
Item number 49.
None appears dismissed.
Item number 50,
No instruction, my lord.
No instructions dismissed.
item number 51,
Item number 51 on behalf of Mr. Patnaik, I may be permitted, my lord. My lord, the petitioner filed the present case challenging the order dated 10th of October 2017 and 11/12/2017 passed by the London JMFC Bhubaneswar in CC case number 1379 of 2012, rejecting an application under section 311 CRPC to recall the PW1 for cross-examination. I may be permitted to.
What is it? Was it 302 case? What's the kind of case?
138 negotiable instrument. I am accused.
Recall, at what stage did you recall PW1?
No development has been made.
Case, come to page 11. Case is lingering since 1911-2016 for arguments.
Yes, madam.
And from the accused statement came to the notice of the court that the accused admitted his liability towards the complainant. What is there, sir? Why recall and all? Just pay him, settle the matter.
As per my instruction,
What is the value of the check? How much check amount?
5 lakhs. Madam.
5 lakhs. You pay him at least the principal amount, he'll keep quiet.
As per my instruction, he has paid the amount. Madam.
Then let it go, sir. Because you see, the impugned order dated 31st October 2017, passed by the JMFC Bhubaneswar, declining the petitioner's, you're the accused, right?
Yes, madam.
Petitioner accused's application under section 311 CRPC for recall of PW1 was rejected. To stop, the impugned order reads as under, just reproduced from page 11, at order date 10/10/2017. Impugned order dated 10/10/2017. Having heard and counseled the petitioner, the court is not persuaded that the JFC has committed any error in declining the prayer of the present petitioner. Consequently, the court dismisses the present petition. The interim order is vacated. A copy of this order be sent forthwith to the JMFC Bhubaneswar. All right.
Public.
item number 52,
None appears dismissed.
53,
May I please, your lordship? My lord, the facts of the case is that, my lord, one FIR has been lodged against the present petitioner under section 147, 148, 294, 336 and other offense. One of CRPC. After that, my lord, within these proceedings, his vehicle has been seized, and for the release of vehicle, he has furnished a bond, my lord.
Bank guarantee.
50,000. Application for releasing of that bank guarantee. And my lord, Lawrence trial court has rejected that petition on the ground that there are 2 other accused persons are absconded and absentee.
How can that be the ground, sir?
Therefore, my lord, that 50,000.
Bank guarantee has been submitted by the petitioner.
I know.
He is
Poor man, he's acquitted.
Therefore, my lord, that.
All right, all right. The challenge the present petition is to an order dated 8/10/8/1/2015, passed by the Additional Session Judge Bhubaneswar, in an application filed by the present petitioner for return of the bank guarantee furnished by him. Consequent upon his acquittal. Paragraph. It is seen from the impugned order that the prayer is rejected only because there are 2 absentee accused persons. Full stop. That can hardly be the ground to reject the prayer of the present petitioner who has in any event been acquitted. Paragraph. Consequently, while setting aside the, but have you kept this bank guarantee renewed?
My lord,
if it's not renewed,
That is also whether it is valid or.
no, it's applying the mind. That's all problem. Okay, while setting aside the impugned order dated
Law has also not applied mind on that.
8 January 2015 of the Additional Session Judge Bhubaneswar. TR case number 15/4 of 2004, the court directs that the bank guarantee furnished by the petitioner be returned to him forthwith. Full stop. The petition is disposed of the copy of this order be sent to the concerned trial court forthwith. Urgent copy be issued as per rules.
Right, I know.
Item number 54.
May I please? Milord, petitioner is a journalist. I am in the PC, Milord.
Yes, yes.
Petitioner is a journalist and at the relevant time working from Balangir. The FIR is against the unknown person and your lordship is the petitioner presently before lordship challenging the order of issuing NBW straight away. I don't know, even without taking cognizance, your lordship can see the page 8 for a moment. What he has written, my lord, probably prosecutor can say better, but I am not able to read what is written. I am not able to.
Absconder in the charge sheet.
No, before that, what you have written, your magistrate is written, what he has written, I do not know. It's bailable, offense bailable, and without issuing someone and anything, because my lord, your lordship knows either the journalists are very close to police and otherwise very few are they're working the police doesn't like. It's a very unholy combination of the people.
Yes.
So what he has written, magistrate, I am not able to read, my lord. My lord can read better. And what is BPP, I could not know. What is that act without reading the full? And all the offences are bailable. And
And
I
you
have
have to-
never received someone
You
anything.
will take some instructions.
Let him go and
To teach
apply
me
for
a lesson
No,
behind
no,
my back.
what is this? What is this? All scribbling. I'm not able to read. Are you able to read?
Yes. Large public prosecutor
I am
can read.
satisfied that prima facie case of the offense under section 147, 336, 427, 189, 149 IPC, 4 PDPP Act is well made out. Hence,
No, but this man is a
taken thereafter.
And I am not able to read where it is what taken is written. My lord friend can read it.
cognizance taken is there.
No.
That dash is there. That is
No.
Is there. So casual in writing, I can't imagine a SDGM. But anyway, it is their privilege.
No, so we had anyway called for a status report from the concerned court. I think.
Yes, I'm giving for the office note that I don't know what is that office note, Malon.
Has it come? Report not yet received. All right. You see, a specific order will pass with this court on 24th September 2018, asking for a status report from the concerned court. That is the court of the
SDJM Balangir.
SDJM Balangir, before whom GR case number 784 of 2009 is pending. Full stop. The registrar administration will again requisition such a status report from the concerned court before the next date. Interim order to continue list before the roster bench on 3rd April. All right.
There are 3 to 4 cases like this. Again, unknown FIR. He has been thrusted with the cases.
Oh, I see.
Journalist.
All right.
Probably was not peli with the police. The offense is all bailable and is vague. The FIR also. Anyway,
Right. Yes.
Item number 55.
I will grant me liberty to raise my points.
Permitting the petition to raise all, please.
Item number 56.
Please, your lordship, Lords, here I have come up against my rejection of my 205 petition. That is at the annexure 3, Milords, I am on bail, Milords.
You're already on bail.
We are on bail, Milords.
This is infractuous then.
Milords, the only problem is day to day, Milords, appearance is not to be insisted because the petitioner
That you can apply, sir.
Milords,
That's
I
not
have
the order
applied.
here.
What the order is at annexure 3, my lords may kindly see.
No, but there's no interim order here. So anyway, when you go now, you can again apply afresh. These are not orders forever, sir.
That's the only
fact. The petitioner points out that the petitioner is already out on bail. For any petitioners are already out on bail. For any future occasion, on any future occasion, when the petitioners need to seek exemption from appearance on any particular date, it will always be open to petitioners to apply to the court concerned, which will then deal with such plea in accordance with law.
Grateful.
The petition is disposed of.
Item number 57.
None of this discussed. Bail, I don't know. That bail application has to be dismissed.
Item 58.
1 minute, you have to find out if all independent witnesses had been examined in this matter. We'll just pass it over. 57 pass over.
Item number 58.
May I please? Chair, my lord, I have come up before lordships to pass the cognizance dated 16/10/2015 at page 19. But the fact of the case, your lordship will find at page 16.
420, 468, 470.
No, my lord, your lordship may just apply this fact, my lord. Fact remains that, my lord, one Saubhagini BC, in favor of whom, my lord, a contract was executed by the Public Distribution Department. And by and she has performed as per the, and she has misutilized that, she has breached the contract, as a result of which there is audit report and misappropriation is found. But my lord, whenever the present petitioner is concerned, nothing is there. I am not a part of the contract, or I am not the executive.
So these you take the appropriate states. By now, what charge has been framed or not framed?
No, only after cognizance I have come before your lordship, and it is your lordship was.
Today is all pleased with the appropriate.
And one prayer I will make.
Yes.
One, my lord, your lordship may target that.
That you can always do, sir. It will be open to the petitioner to seek, to request the trial court for expeditious disposal of the case.
Right.
All right, deploy.
Item number 59.
None appeals dismissed.
Item number 60.
None appeals dismissed.
Item number 61.
May I please? I have come up against the rejection of a 311 CRPC petition, my lords. Before that, my lord, I have two interim applications. The first one, if your lordship would finally dispose of, that is IA 96 of 2021 will not be necessary. But the second one, that is IA 97 of 2021, the
deletion of the name of petition number 1.
One, because who is already dead, my lord. I have annexed the death certificate, my lord.
All
The
right.
death occurred on 5/9/1990.
All right.
2019.
So the reason stated there in 97. The application is allowed.
Yes.
In view of the death of petition number 1.
And that may be also deleted from the lower court records. Not, I'll make an application.
That will make an application.
And if your lordship would kindly see the complaint petition, I have a very humble prayer, my lords.
1 minute. This application is allowed. It's deleted from the array of parties. 96, you say the application has become infractuous. It's disposed of as such. Yes.
Look, here the allegation is a complaint lodged under section 209A8 of the Companies Act. And the allegation, my lord, is that the accounts were not given for inspection, where I have taken a specific plea that they were all lost during the super cyclone of 2009, my lords. If your lordship had just given a complaint petition, my lord, here the my lord is filed on 5th of November 2004, my lords. And if your lordship would kindly permit me, I'll place 209A8, my lords, of the Companies Act, my lords.
That's for the, no, who appears for the assistant registrar of companies?
Company.
You're there.
No, register of
ROC,
companies. ROC.
Somebody will have to hear the ROC. You're for the ROC. You're there in this matter, or you don't have the petition? Yes.
If your lordship would, I'll just complete it within 5 minutes. 311 petition.
Here, challenging that the petition rejected and it's filed under 311.
Let him go back, let him re-examine, no problem.
I had just this humble prayer, my lords. The maximum punishment, my lord, is fine in 1 year.
No, but that prayer is only for order.
Your
And
lordship, trial court has rejected the application on the ground that no ground is sufficient. Why the witness was not cross-examined? Why that was recorded declared? The reason they have not.
Your lordship would appreciate, this is the amount of bill they give me to deposit in the court, my lord. Your lordship will kindly have the look, my lord, to recall that petition, my lord. But I was handicapped because business class airfare, 7,500 in 2016, my lord. They say that per day you have to pay this amount of 7,600, 71,000 some odd in the year 2016. It must be more than 1 lakh now, my lord, if they stick to this, my lords. Not here, my lord. No, true, my lord. This is
no. You do it virtual now.
No, this
you do the virtual examination, sir.
Yes.
You're traveling nothing.
Your lordship
Now it's hybrid.
Your lordship may kindly clarify that.
Yes.
And unfortunately, my lord, except this particular witness, not a single.
Kindly have a glance over these.
So he has to just sit before his laptop and open it, sir, and appear.
No, in the alien petition, they have not said what question they want to ask. That is not with your lordship. Is
Anyway, my lord, he's a vital witness, my lord. He's the inspecting officer, my lords.
what he has written. Only that you are not cross-examined, I want to cross. That is what question he has to ask. That has not been.
All right, you say the present petition has been filed, questioning an order dated 29 November 2016, passed by the learned Additional Chief Judicial Magistrate (Special Cuttack), rejecting an application filed by the petitioner accused for recall of PW1 for cross-examination by filing an application under section 311 CRPC. Paragraph. The learned trial court has rejected the plea only on the ground that the accused persons did not state open condition on which ground on the relevant day the cross-examination witness, who is a public servant, being the registrar of companies, come from West Bengal is declined. Unquote. Paragraph. Mr. R.P. Karel, learned counsel appearing for the petitioners, submits that by the time counsel for the petitioners could reach the court on 25th February 2008, the witness already stood discharged, and the order sheet erroneously noted that cross-examination had been declined. Full stop. Further, counsel for the petitioners did not inform them of the above development. Full stop. Paragraph. It appears that the petitioners have been prejudiced on account of the conduct of their advocate in not informing them of the correct dates of hearing. Full stop. This being a case under section 209 capital A bracket 8 of the Companies Act 1956. It was essential for the petitioners to be permitted to cross-examine the registrar of companies, who's the prime witness, and perhaps even subject them to terms if it was so required. Paragraph. In these days of hybrid hearings, it may not be necessary any longer for PW1 to remain physically present before the court for the cross-examination. Full stop. Much of the trouble can be avoided by indicating a specific date and time for PW1 to remain available online for cross-examination by counsel for the petitioners. Paragraph. In that view of the matter, the impugned order is set aside, and a direction is issued that the learned ACJM Special Cuttack will resume the proceedings in 2C number 2004 by fixing a date for the virtual appearance of PW1 for the purposes of cross-examination by the petitioners. Full stop. It's made clear that on the date fixed by the paragraph, the matter now be the aforementioned case, that is 2CC number 2CCC number 427/2004 be listed in the court of the ACJM bracket Special Cuttack on 2nd March for directions. The copy of this order be sent forthwith to the court. My submission to the petition.
Yes.
No problem.
My lord, cross-examination on virtual mode, not for this case. Sometimes I feel it is very difficult because we used to confront the documents to the witness.
I know. Now you have visualizer. So you can show in the visualizer. In fact, today's inauguration,
Yeah.
if you are there, you will notice there's what's called visualizer, document
We
visualizer.
can show in camera.
The whole document can just be placed, the whole document can be,
Oh, I see. That I do not know. because-
all that is possible is eye
because
contact.
our practice is that we used to show the document to
Yeah.
the witness and you verify the document and you answer.
What is not possible is staring at the witness and intimidating him.
That is correct. That your lordship. That is our practice.
In cases of these type, my lord, the body language is not necessary.
Not necessary, that's what. You're right.
Demeanor, we cannot examine the demeanor of the witness.
No, that you can't. In all cases, it may not work. You're right.
Yes.
It may not work in all cases.
The may I just please, humbly pray, my lord, your lordship, may just add a line. The link may be provided by the counsel for the registrar, appearing for the registrar.
Yeah, they will organize it.
Huh.
The trial court knows all that now.
Trial court-
There is a virtual court in
There is a
Cuttack
system.
itself.
My lord,
No,
This will happen in that virtual court.
in Cuttack, they have set up a system
That's
for
what-
all these things.
we are grateful to your lordship for all those arrangements.
It'll all change. It'll all change.
My lords. It has become less expensive also.
Yeah, correct.
Gratefully
Actually,
blessed.
COVID has been a big learning for
My
all
lords,
of us.
my lords.
All right.
Much obliged, my lords.
My pardon, my lord, item 60, my lord, non-appearance, just like item 60, my lord.
Tell us.
Non-appearance is, my lord.
No, so you tell us, what is the matter, boy?
My lord, matter, my lord, is a compromise. Both parties are opinion number 2 is the petition. Accused petition number 2 is informant. Last date.
Some more time.
With the interim protection, and we will go to director to
Yes, he will need time because that was in 2017.
my lord. Offense, my lord, 341, 322, 354, 34, I will be only non-conformable offense, STSC Act, Atrocity Act 32, Military Act
A
2000.
specific direction was issued by this court on 30th June 2017 for recording of the statement of the victim under section 164 CRPC by the special judge Rourkela in PS case number in Tangarpalli PS case number 111 of 2016. Paragraph, a report will be called for from the special judge Rourkela, as well as a copy of the said statement, if any, that has been recorded before the next date. Copy of this, you say the list before the roster bench. Administration will call for it. List before the roster bench on 4th April.
Item number 62.
Interim order to cut.
List.
My lord, with liberty to raise all the points before the court below.
Permitting the petition.
Item number 63.
None appears dismissed.
64.
As for the petitioner through VC, my lord. In
Yes.
this case, my lord, the petitioner was suffering from the cancer at the time of filing the case. Till now, I am not able to contact him to know his present position.
All right, at the request of counsel of the petitioner, list before the roster bench on 27th March. Is there an interim order?
Yes, my.
Challenges the rejection order, against rejection under section 205 CRPC petition filed by the present petitioner, my lord.
It's okay, sir. Now you can apply fresh. There's no interim order here.
No. Petitioner
There's
is a
not-
lady.
Due to passage of time, the present petition has been rendered infructuous. In the event that the petitioner wants to seek exemption from appearance at any future occasion, it will be open to the petitioner to apply to the concerned trial court, which will then decide the application in accordance with law. The petition is disposed of.
Item number 66.
My lord, the file is missing, so my lord.
Yeah, dismiss for non-prosecution. With permission to revive the petition if the file is found out.
Item 67. Not pressed, my lord.
Not pressed, dismissed.
Item number 68.
My lord, item 68, we are for the informant opposite party number 2.
None appears to the petitioner. Dismissal on prosecution.
Item 69.
Matter has been informed to us, my lord.
All right, dismiss this in practice.
Item 70.
May I please your lordship? Lord, petition is a police officer and cognizance is taken. But there is an interim order. And there is an interim order earlier. But yesterday. Yes, CST, my lord, here the case is, my lord, very well peculiar case. Police FIR was registered 354 SCST Act. Police filed a final form. A case was registered before the Mahila police station. He filed a final form stating there then there's a case total because the informant, the lady, has a paramount. He was arrested by the petitioner in while taking cognizance, without giving an observation, running page 31, he says that since final report was submitted, there is every possibility that IO in GR case has overlooked to examine some material witnesses, as the accused is a police officer and there is chance of business or biasness on the part of the IO. If he can investigation, so in a protest petition, how can he give these types of observation without giving an observation regarding the prima facie material? He took cognizance in a protest petition. I have annexed the Annex 4, which is the police report, where final form has been submitted on that. Format, and what this is alleging is a prosecution case is that victim came to the police station to lodge an FIR saying that while she was in temple, someone has snatched his purse. And during investigation found to be false. And police has submitted final report. Thereafter, she came and lodged an FIR in the Mahila police station. It was investigated by a high police officer. They filed a final report. She is not satisfied. She finally submitted a complaint petition in shape of the protest petition. And in protest petition, the finding of the while taking cognizance.
Has she been served here?
Pardon?
Has the complainant been served here?
Notice was served, and there was on 7/4/2017. Notice was issued to the complainant.
Mr. Ragada is appearing.
Appearing.
Where is he? We'll pass it over once. We'll pass.
Item 71.
No instructions.
Item number 72.
May I please, your lordship, I may be allowed to appear to VC, my lords.
Yes.
We have been trying to contact our clients. Your lordship may kindly
There's no interim order, nothing, sir.
No, my lords. We just have filed our requisites, my lords. Way back in 2017, we have filed.
No, then there's no stay also here.
No, my lords. No.
So we just permit you to raise all pleas, sir. Permitting the petition to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. All right.
Item number 73.
My lord, item 73 I prefer adjournment because the file has been misplaced
That's
somewhere.
okay. Then we permit you to revive it. Trial misplaced, dismiss and non-prosecution. Permission to revive it as and when the file is found. All right.
My lord, withdrawn.
All right. Dismiss is withdrawn. All right.
May I please, your lordship, I am appearing on behalf of opposite party number 2.
All right. This note her presence.
Item number 74.
Case, your lordship, under 130 denied, my lord. The amount is 2,20,000, my lord. The petitioner has agreed to settle, my lord, and someone has appeared for the opposite party, my lord. If your lordship permit me one chance with the opposite party.
Let the opposite party be here.
Yes, someone appeared, KK Pahil, Mr. KK Pahil. Already
We'll
appeared.
pass it over. Pass it.
Item 76.
Item 76. My name may be recorded.
77.
76, opposite party number 2.
Note
Manu.
presence. All right.
77.
Yes, ma'am. May I please your lordship? There is a civil suit is pending. The nuisance before this plot of suit plot, so that the FIR was lost and the civil court have issued the notice. Still then they have creating the nuisance, and so for that the accused are now creating the violence on this place. So
It's all right, sir. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of, the interim order is vacated. All right.
still that no nuisance, no nothing.
All right.
Maintain silent on that plot.
All right. Yes.
Item 78.
78 may be disposed of, granting me liberty to raise this point.
All right. Permitting the petitioner to raise all pleas at the appropriate stage.
Grateful.
79.
And in this case, I am praying for time because of the fact that it is a matrimonial dispute. Now the wife is residing with the husband.
I see.
If your lordship will grant some time, we will file an affidavit.
All right. Counsel with the petitioner states, okay, you are agreeing. You're for the wife.
Let them.
All right. Counsel with the petitioner states that the parties are now happily staying together and she would file an affidavit of the wife on the next date. At her request, let's go for the roster bench on 10th April.
Item number 80.
None appears dismissed.
81.
My lord's permitted to withdraw.
Dismissed is withdrawn. Interim order vacated.
Item number 82.
82, my lord, liberty to raise all points.
All right. Permitting the petitioner to raise all pleas.
Item number 83.
None appears dismissed.
Item number 85.
Same order.
Item number 86.
May I please, lordship? There are an application under section 457 of CRPC for releasing a vehicle. To that extent, your lordship.
What is this vehicle?
Vehicle is in police custody.
No, what is the vehicle?
Vehicle is
Car, truck, what is it?
car, four-wheeler, bolero.
What car, sir? Car?
Bolero pickup van.
Bolero? Pickup van?
Madam.
So where is it now? Still in the police station?
In police station. My lord.
You've seen it?
Mm.
Have you seen
I
it?
have not taken.
Which is the police station? Which is the police station? Khurda. So it must be here only in Bhubaneswar only. Last time the court had asked you to find out if the vehicle is still there or not.
I don't have the copy of the petition. Can you give me the copy of the petition? Copy of the petition.
I will see.
Copy of the petition be served forthwith upon Mr. Katkia to enable him to take instructions as directed by this court in its order dated 28 November 2018. Let's move for the roster bench. In March.
Item number 87.
None appears dismissed. Interim order vacated.
Item 88.
Same order.
Item number 89.
The order of taking cognizance under section 48/2017, my lord. In the meantime, my lord, the petition number 1 has already married to the opposite party number 2 before marriage of sir, my lord. They are also present, my lord.
All right.
Blessed with a male child.
All right. Counsel to the parties informed the court that petition number 1 has already married the complainant.
Opposite number 2, my lord.
Opposite party number 2.
Sonali Maharana.
Additional affidavit has been filed by her, certifying to the above effect. The
Also-
affidavit is taken on record. In that view of the matter, GR case number 845 2017 arising out of Colliery PS case number 121 of 2017 pending the court of the SDJM Talche consequent thereto and orders consequent thereto are hereby quashed. The petition is dismissed.
Item number 90.
Yes.
My lords. The petitioner is in custody since 28/10/2020, my lord. An offence under section 302/201/34 IPC, my lord. In the meantime, charge sheet has been filed and last occasion, my lord,
Also directed me to text instruction on the progress of the trial. Because only one line instruction has given, there is no information there. There is the trial of evidence for trial, evidence of prosecution witnesses, and next date is fixed to 6/2/2023. Nothing there. Either again, I have to take instruction or else through registry also we can get it.
Last occasion, and Mr. Katke has praised for one more adjournment to seek proper instructions. I think next Friday, 10th.
Specialist pastor matter. Item number 39.
May I plead your lordship?
Yes, please.
Lordship is a order taking cognizance is under challenge. Lordship by order dated 4/11/2022. My lordship's order, I have filed the requisites for OP number 7. Here, lordship, the petitioner is the complainant petitioner in the complaint case. The cognizance has been taken in the lesser offences. Prima facie, I have established.
No, have they been served?
Lordship, my requisites I filed on 10/11/2020.
Requisite filing is one thing.
Lordship.
Not yet back. This is the whole problem.
Lordship.
Where is this opposite part number 7? Baleshwar.
Lordship.
Can you serve them Dasti?
In fact, your lordship also directed Dasti.
Ah.
We tried.
Ah.
It was not possible.
Ah.
The party even yesterday night said he made all efforts. He's not entertaining that it was difficulty.
But some affidavit has to be filed then.
But if your lordship asks for the postal track report, that will solve the issue and your lordship may fix a date.
All right. What is the track report? There's no track report. All right. You say there is no report of service on record. Mr. Mishra states that the opposite party number 7 could not be served by Dasti. Paragraph. You say fresh notice by registered speed post returnable before the roster bench on 22nd March. The tracking report will be placed on record. Interim order to continue.
We'll file requisites again, my lord.
Yes.
Through speed post.
Speed post.
Grateful, my lord.
Pastor matter item number 57.
Despite a Passover, so that bail applications. This, I think here also the status of the trial was to be asked for. Present status of the trial.
No, letter has gone, but we have not received the status by now.
All right, Mr. Katke seeks for one more opportunity to inform about the current status of the trial.
Opposite party did not appear, my lord. This case is a police officer. I was just arguing before lordship. It's a police
You say,
officer.
all
It's a
right, you
malicious
say
prosecution.
despite a Passover, Mr. Ragada, who's entered appearance in behalf of the respondent, does not appear. See, interim order to continue list before the roster bench on 29th March. All right.
Interim order.
Item number 75.
Here is
unless they come, what's the point, sir?
Lordship, only point is I am ready to the instruction I have obtained from my client, my lord. He is ready to settle the amount, my lord.
Despite a Passover, Mr. Pahil, KK Pahil, counsel for the opposite party is not present. Let's say list before the roster bench on 5th April. The registry will inform Mr. Pahil to remain present on the next date. Right.
First list.
May I please, Your Lordship? On the board, Your Lordship, there are two matters. One is a writ appeal and other is a review petition. The writ appeal has been disposed of on the basis of WPC number 535/2019, against which the review application has been sought, in which my learned senior is appearing. So let him begin, Your Lordship. I will supplement.
May I please, Your Lordship?
Yes, please.
Here, my lord, the kind of a glance to page, my lord. It starts from page 50, my lord, the relevant order. Order dated 28/11/2019, my lord.
Yes.
My lord, may I read it, my lord?
Yes, please.
By way of this writ application, the petitioner have challenged the action of the opposite parties in publishing request for proposal of RFP BID as per the advertisement dated 22/2/2019 under Annexure 1 for hiring of the agencies to provide manpower support to the rural sanitation work. Mr. Acharya, the learned senior advocate appearing for the petitioners, submitted that in the year 2005, the petitioners, after being successful in the selection process, were appointed as a district project coordinator (DPC) and district level consultant (DLC) and assistant project coordinator (APC) on contractual basis. While continuing as such, the opposite parties, instead of extending the contract period published in the advertisement to fill up those posts, though through outsourcing agencies, it is his submission that the ideal employer like the state government cannot substitute the contractual employees who are in employment through another set of contractual employees. He has mainly relied upon the decision of the Honorable Supreme Court in the case of State of Haryana versus Parasing, reported in such and such, wherein the Honorable Supreme Court has categorically stated, my lord, that has been quoted, my lord, that the basic concept is the one set of employees, they cannot be substituted by another set of contractual employees, my lord. These petitioners, by way of advertisement, since 2005, they are relentlessly continuing for a period of 10 years, and end of the service was March 2019, when they came up in another way of advertisement. And this person, and all these persons, those who have employed, they are all postgraduate degree holders in social science, having 5 years of experience in this line. They have been worked for relentlessly for a period of 10 years, my lord. Then, my lord, coming to the para number 4, taking into consideration the decision of the Honorable Supreme Court in case of the Parasing of the Honorable Supreme Court, has observed that under this contract regulation, labor regulation and abolition act of 1970, if contractual employees is to be replaced, it is always advisable to incorporate one of the conditions in the contract that it should be substituted with the earlier set of employees. Since the petitioners were appointed on contractual basis, end of justice will be served if the petitioners who have served under the state government for more than 5 years and they are being experienced, if they are otherwise eligible, they should be given preference for appointment, which is to be made by the contractor who has been selected through the impugned advertisement. My humble submission would be, if at all we are continuing under the state government since more than 10 years.
You are aware you are arguing a review petition, correct?
My lord, I know my limits, my lord.
If you know the limitation, you should argue accordingly, sir.
My lord,
if you know that limitation, you should argue accordingly.
My lord, only to that ground, I should be, which is to be made under the contractors. My lord, my humble submission, all through, I was working under the state government by way of an advertisement. And for a period of 10 years, I was working, having all the master degree experience as well as 5 years.
That's arguing the matter itself, sir. What is wrong with the order that you'll have to tell us?
That is, I should
Can I supplement, Your Lordship? My kind permission, my may kindly see the advertisement.
We are not entertaining his plea at all, sir. We are not
entertaining it. I'm just supplementing, Your Lordship.
No.
No.
You're arguing in his support or against him?
I'm supporting him actually.
I don't know. This is very strange. Yes. What is wrong with the order, sir? You have to tell.
And I'm saying, when by virtue of the advertisement by the state government.
See, that's on the merits. You're missing the point about the review petition, sir. There has been error apparent in the face of the order.
My lord, the contractors, So which is to be made by the contractor, my lord. I am on that point, my lord. I should have been, because there are vacancy of posts are available still under the department.
All right, sir.
I should have been abjured, because without considering my case, they have gone for an advertisement,
Right.
and that too by reducing the experience from 5 years to 2 years.
Right.
And these persons are all postgraduates,
Right.
and they are sought for the, so far the qualification is concerned, they are all graduates.
Right, sir. All right.
So my 10 years of relentless service, that could not be considered.
Right.
Yes. And there are vacancies, my lord.
All right.
I could have been considered keeping in view my
All right.
suitability, experience and all these things. That is my.
All right. No grounds made out for review. The review petition is dismissed. Yes.
In the appeal, your lordship,
Yes.
I'm challenging Annexure 1 at page number 15.
Yes.
The Honorable Single Judge, on the
Yes.
basis of the order passed in
Correct.
WPC number
You are
535.
identically placed like those people.
It's the association, your lordship.
That's right.
Now, my claim is entirely different from theirs, your lordship.
Uh-huh.
My claim was for regularization.
Hmm.
And so, my lordship, will kindly see the impugned order.
Hmm.
It has been disposed of on the basis of WPC number 535/2019.
Correct.
My lordship.
You just saw.
Yes.
Yes.
My lordship, my entire case is,
Yes.
I have been appointed where in the year 2005, your lordship.
Yes.
I have worked for more than 13 years, 14 years under the government,
Correct.
who was my employer, your lordship.
Right.
Now they have come with an advertisement
Yes.
where under they wanted to replace us
Right.
with another set of employees who were also appointed through a manpower agency under outsourcing basis, your lordship.
Right.
I have prepared a bunch of judgments, your lordship, for your lordship kind perusal. I'm sorry to Mr. Justice Mahapatra, but I am not able to supply the copy. For a moment, I kindly consider, your lordship.
Yara Singh.
Time and even apart from Singh, your lordship will kindly see
Hmm.
page number 5.
Yes.
It's a Supreme Court judgment, your lordship,
Right.
where under
Manish
also,
Gupta.
yes, your lordship,
Yes.
where under also these petitioners, they were working under a scheme.
Yes.
And now the Honorable Apex Court
Yes.
at page number 10 noted the contention of both the parties, your lordship,
Correct.
and accordingly directed at page number 14, your lordship.
Correct.
At A, B, and C's are the orders, your lordship. The
Right.
C portion is that the judgment and order dated 29 September 2016, passed by learned single judge of the Honorable High Court, is modified as under the writ petitioners appellants herein would be entitled to continue on the respective posts.
Yes.
The sole basis of Singh, your lordship already knows. I don't have to reiterate it.
Yes.
The writ petitioner appellants herein would be continued on the respective posts, provided that a sufficient number of students are available for the particular course for which the petitioners appellants have been appointed.
Yes.
Yes, your lordship. Now, my entire argument is, your lordship, the association is comprising of 160 number of employees, your lordship.
Right.
Now, in the advertisement, the government decided to disengage everybody. They didn't want to continue with their services. No prior notice was given. Now, subsequently, your lordship, advertisement was floated. Advertisement was for 48 persons, your lordship. Now, out of 48, your lordship, not even 12 persons were appointed. We were already continuing, your lordship. Now, consider hardship, your lordship. These petitioners have already put more than 14 years of service.
Right.
Instead of regularizing their service in terms of any scheme, your lordship, or
Yes.
considering the Uma Devi,
Right.
they have been thrown away. They have thrown out, your lordship,
Right.
completely washing away the past period of service.
Yes.
And even if we kindly consider judgments, your lordship, it
Right.
is in my favor.
Yes. Yes. You see, you're the same organization, sir.
Exactly.
Yes. You say the challenge in the writ appeal is to an order dated 5th December 2019, passed by the learned single judge, dismissing writ petition civil 18415/2019, filed by these petitioners. Paragraph. The petitioners.
It was disposed of with a direction that it should be disposed. No, what is this?
They were protected earlier, man.
They in terms of that earlier.
Harassing case, your lordship has protected them.
All right.
Yes.
Difficulty was the posts were 48. There were 116, your lordship.
That's right. That's right.
And these
You
are
say-
all ongoing projects, my lord.
Right.
Still continuing, they require manpower, your
Yeah.
lordship.
All the petitioners who were engaged on contractual basis to work as district project coordinators, assistant project coordinators, and district level consultants under the drinking water and sanitation mission of the Government of India. Full stop. In regard to an identical set of employees who had filed writ petition civil 5358 of 2019 with the same, praying for the same relief, namely regularization of their services on account of
The prayer
long
was not
years
same,
of
Your Lordship.
service.
Prayer was not same. Prayer was different. Prayer was not same, Your Lordship. Our prayer was for regularization. Their prayer was for continuance in their work, not regularization.
No.
And they challenged the request for proposal, Your Lordship. Not same prayer.
Let's see this.
With your Lordship kind permission for a moment, but if your Lordship will permit for one line only.
Yes.
Your Lordship is correct because the other case has been already delivered where the advertisement was the subject matter of challenge, tender was challenged. In this case, the association along with the employees, they have come to your Lordship. Lordship kindly look to the central government directions. If that can be disposed, if Lordship can dispose of, they can take their plea before the authority, taking into consideration this. That will at least suffice, at least help them at least to render for 10, 13 years of service. Let's look to the last paragraph. They cannot, I'm sorry, I can't, Justice Mahapatra, I should have given a copy at least, but I'm serious. Let them consider. Not the only thing is, so far as the review application is concerned, I do agree. My Your Lordship said that since a case is not made out, review application cannot be, Your Lordship, within that parameter. My Lord,
this is some Swachh Bharat mission. And
yes, sir, this is same.
It is also a project
You also only permit us to make a representation, let them consider.
That whatever is there, sir, in our order earlier, I think that takes care of all of this.
Exactly.
That takes care of all of this, sir. You see, in another set of employees had filed a petition civil 5358 of 2019, where inter alia, a direction had been sought to extend the period of the contract of the said petitioners to allow them to continue in the posts, while challenging an advertisement dated 22nd February 2019, inviting tenders for the same contract work. Paragraph. That writ petition was disposed of by a division bench of this court by an order dated 28th November 2019, where inter alia, the following directions were issued. This reproduce whereas 4, 5, and 6 of the said order. You can find in the review petition, page 51. Paragraph. In the present case, while the prayer may have been for regularization of the services of the petitioner, in effect, the prayer was not to disengage the petitioners. Full stop. Which is the same as the prayer, in effect, the prayer made in writ petition civil 5358 of 2019. Paragraph. Consequently, as far as the present case is concerned, the impugned order will under single judge disposing of the writ petition open petition, directing the opposite parties to work out the claim of the petitioners as per the direction contained in the above writ petition, unquote, cannot be faulted. Paragraph. The court's attention has been drawn to a subsequent instruction dated 24th February 2021, issued by the Ministry of Jal Shakti, Swachh Bharat Mission (Grameen), Department of Drinking Water and Sanitation, as regards hiring of project management units. Full stop. While considering the case of the petitioners, it is obvious that all instructions applicable at the relevant time would be taken into account. Full stop. The court therefore finds made out for interference with the impugned order of the land single judge. The writ appeal is dismissed.
Can your lordship may kindly modify to dispose? At least they will consider your lordship. We cannot force the government.
That order is already there.
Might we dispose
It
it
is already there, sir.
The writ appeal is dismissed doesn't mean the writ petition has been dismissed, sir.
In this case, my lord, for opinion number 1, Jal Shakti Wari, appearance to note.
All right, all right. All right.
Yes, sir, yeah, that's the number.
Right, thank you.
Similar, the lordship, the ground I have taken in para 3 and 4. 5 your lordship. The lordship has come to a conclusion that his senior pay to be fixed. But we have taken the ground why his pay cannot be fixed. Lordship can hear para 5.
Yes.
The only problem is that Dibakar Mishra was initially appointed as peon, subsequently promoted. But this man is initially appointed as a driver.
It's all right, sir.
So, accordingly, on granting of SCP, his pay was fixed above him. That is the ground for which his pay was fixed above him. But your lordship treating him as if, as he was junior, your lordship was directed to protect his pay. This is the anomaly because of that he got promotion and SCP was fixed in 2011. Subsequently, he was appointed as a driver. Accordingly, he got the higher pay. That is the only ground.
No, but you had not disputed in para 6 of the counter that he is junior to the petitioner as a regular driver.
Yes, ma'am, both.
They are admitted errors.
He was initially appointed as an ad hoc basis. Subsequently, that is initial appointed. There is no dispute, my lord. And we have his pay was fixed with effect from the date of his ad hoc appointment.
Right.
But that Dibakar Mishra was initially appointed as a peon. He was originally senior to him. He got SCP on completion of 15 years in 2011. So by SCP, he got one increment ahead. Accordingly, his pay was fixed higher than that Dibakar. This is the anomaly only. This is the.
That's all right.
Yes.
No grounds made out for review. The review petition is dismissed.
Obliged.
All right.
I don't know.
Namaste.